Good morning, and thank you for joining us today for this program on federal and state employment law updates. This program is being recorded and will be shared on our chamber website for future listening. Before we get started, I just want to share that all attendees are currently muted for today's program to avoid background noises. However, the chat box is open for Q&A, so please feel free to submit questions in the chat or raise your hand during the Q&A segment. Time permitting, we'll do our best to answer your questions at the end of this presentation. If we run short on time, we may need to follow up with you afterwards. We are very appreciative and thankful to have Mike here with us this morning to share the latest updates of employment and labor law matters and making sure we are prepared to handle them. Mike Carruth is a partner in the Columbia office of Fisher & Phillips, LLC. He is certified as a specialist in labor law by the South Carolina Supreme Court. Mike, thank you for joining us, and we look forward to your remarks.
Simone, thank you very much. Good morning, everyone. Thank you for taking time out of your busy day to join us today for this webinar, Federal and State Employment Law Update, sponsored by the Berkeley County Chamber of Commerce. I want to thank Lane and Simone for all their work on getting this program together. They do an excellent job on making sure that the chamber members are kept up on current issues and items, and I'm very thankful to be part of that. Again, I'm a partner in the Columbia office of Fisher & Phillips, and if you have the need or desire, you can look at our website at www.fisherphillips.com, and there's a lot of free content there, a lot of the things that we'll cover today. So with that, we'll go ahead and get started with our program. First, a legal disclaimer. Obviously, a lawyer is going to start off with a legal disclaimer saying that this is not legal advice, although as you listen to me talk about legal issues, you're going to say, well, what else is this other than legal advice? But it's not direct legal advice. It's just informational and giving you some areas and items to be thinking about. Our program today is going to be cover a broad spectrum. We're going to talk about a number of different topics. It's going to be a general legal summary. We're going to cover both federal and state laws. And we're going to talk about certain current requirements, things that are in place now that we see employers asking questions about. And some of them are going to be future issues that folks are having to deal with. First, let me talk about the South Carolina issues and concerns here. There's really not any specific new laws, legislation, court decisions that I felt were necessary to cover with you today. But there are a few things that are bouncing around in the State House that you may have heard a lot about or have received information on and may have some interest in. First is the medical marijuana legislation. I think there was a recent House committee that voted to pass that forward. So the South Carolina House will be voting on the South Carolina medical marijuana legislation. It has already passed the Senate, so the House is dealing with the Senate version of the bill. When it is passed, and I do think everything you're hearing that it will be passed, it will be the most conservative medical marijuana legislation in the United States of America. Right now, there are about 37 states and 4 territories that have medical marijuana laws. You can counter that against the states and areas that have recreational use. There are 18 states, 2 territories, and Washington, D.C. that allow for recreational use of marijuana. I think the D.C. point there is kind of interesting. But that's what's going on in our country. So we get a lot of questions about this. A lot of employers have issues with this. But again, the South Carolina law is going to be the most conservative. There's no obligation, or will be no obligation, to accommodate people that have a medical need to use the very limited type of marijuana that will be allowed on your premises or on your property as an employer. You can't prohibit people from being under the influence of marijuana as an employer. And the property owner, even if there was a employer in a facility or a location, the law will allow the property owner to also restrict the use of medical marijuana. I will say one interesting item on the medical marijuana legislation or laws that relate to the use of cannabis. The big issue here is being able to test for under the influence. It's not like alcohol where you can test somebody who appears to be under the influence of alcohol and get a reading at that particular moment that someone's under the influence. Marijuana is much more difficult. So that's one of the problems I think that come up when this issue is discussed. But as it exists right now, there is no medical marijuana law in South Carolina, but I do think it'll be coming. So something to think about, but there will be nothing in that law that will require you to do anything specific or anything differently than you had in managing your employees. I will point this out. If you look at the media reports that come out on this issue, all the media reports talk about how much the citizens in South Carolina are in favor of medical marijuana. You can see 5-1 in favor by some polling sources. 72% of South Carolinians support some type of reform to the current law. So very interesting thing, and I think it will generate a lot of questions and issues in the workplace, but it's not really going to change how you need to do things. Again, I was looking forward to talking and not really getting into too many COVID issues, and I'm not going to do that. But I will say, just as an update on things that would impact employers, it looks like the South Carolina Senate is moving forward with legislation to prohibit vaccine mandates. This is drastically different than previous versions of this bill that were going to impose a tax penalty up to $30,000 per employee for employers who mandated the vaccine. I hope everybody is free and clear of the COVID issue. You manage that and move beyond it, but it is still out there. I'm handling a case that involves an extremely large employer in South Carolina. We have a case on appeal to the Fourth Circuit. This employer has mandated a private mandate of the vaccine, which has worked wonderfully for their facility and their organization. That doesn't mean it fits and is right for everybody, but that's still out there. So it's still an issue. So this law that I'm discussing here is really more impactful for the state and state subdivisions because there'll be prohibitions there. Let me talk about some wage and hour Fair Labor Standards Act update and information. The federal minimum wage has increased for the federal agencies, is up to $15 for government workers. There's always and often legislative initiatives to increase the federal minimum wage for private employers. Currently, it's $7.25 per hour. And again, with the previous increases, it was $11.25 for federal contract workers. So that's out there. We'll talk in a minute about some of the other issues related to wage and hour laws, but that did go up for federal agencies in January. The Biden administration was following through on some of the earlier executive orders that raised that up. And it's pretty expansive on how that applies. And then the increases that I just mentioned apply to new contracts that were entered, renewed, or extended as of January 30th, 2022. Of course, the penalties for government contractors that don't comply with this would be reimbursing unpaid workers and obviously losing the current contract and being barred from future contracts. So haven't seen that be an issue, but it is out there and folks are dealing with it. Some of the more probably impactful things that are going to occur in the future is going to be the Department of Labor has announced that it's going to be more aggressive in wage and hour investigations. In February, they announced that they were going to be putting out into the field 100 investigators to support its efforts and ability to investigate. There will be more lawyers at the Department of Labor to enforce these issues, take matters and employers to court for enforcement. So what does this mean? think you can expect more investigations. If you've never had one, it may not change anything for you. But there are going to be more of these, and the whole thought process, the whole position of the Department of Labor Wage and Hour Division will be to be more aggressive and to try and move forward with this as an initiative. Another issue, in addition to just plain investigations that relate to wage and hour issues, is going to be the Wage and Hour Division has announced that it is joining with other entities. There are initiatives for the Department of Labor, the EEOC, the National Labor Relations Board to coordinate and become more aggressive and communicate more freely on issues that come up in front of one agency that are more of a matter or topic that should be covered by another one. So there's going to be across the agencies at the federal level more of an effort to identify various wage and hour issues that may come up in the context of an employee involved in a union organizing campaign. It may come up as part of an EEOC complaint, where in the past there may not have been as much of a desire or a need or a process for the agencies to share that information. They did, that did occur, but it wasn't something that was directed. So that's going to be occurring. So something to be aware of. I mean, nothing you can really do on that point. The agencies are going to communicate. However, just be aware that the potential for matters to be investigated and brought up is going to be more prevalent. And then the Department of Labor Wage and Hour Division is going to expand the areas where it can investigate what I call whistleblower. I'm handling some of these now in front of the Health and Human Services agency. Has a complaint that I'm dealing with here, which all I can tell you is it's very slanted, and it has taken a long time. So I don't know, with all this additional whistleblower enforcement effort, investigation effort, that's going to be a lot of work, and you can see all the different laws there that will be covered by the Wage and Hour Division. So they're going to have a lot of areas where they can investigate. And again, you can't do anything about that. It's just letting you know that this is out there and that these issues make possible claims, complaints, and having to go through this administrative process more likely. All right, so what are some of the issues that we see come up and we think will continue to be problematic? There's a lot of discussion, information out in the general media about efforts to expand the definition of an employee. And folks that are in the government, in the agencies that are investigating this, will take the position that employees should have the protection and benefits of being an employee. So employers that are improperly identifying somebody as an independent contractor will have issues and concerns. The problem is that a lot of the efforts and investigations that we're seeing now have a lot more to do to increase the number of people that could be targeted by a union. If someone truly is an independent contractor, they cannot be represented by a union. They can't be a union member in the same way and in the same context as somebody that's an employee. So there are issues, and certainly these exist, where the classification of someone could impact whether proper taxes are paid, proper protections such as workers' comp, and those kind of things are provided. But a lot of this at the federal level is really intended to make sure we have more people available for unions to organize. So COVID-19 has had an impact on how employers were using employees and using independent contractors. There are people were short of of individuals. They were trying to get folks in to do work that was needed. And did that increase the use of employees described as independent contractors? Maybe, maybe not, but COVID-19 has had a significant impact on workforces. So I think that has made this issue a little bit more acute. There are so many different tests out there. There's the traditional test, there's the ABC test. You can bet that the test that the federal agencies will focus on will be very expansive, that if you have the ability to control whether you do it or not, that's going to be a problem. That to me is one of the bigger things, not actually showing direct control, which seems to make the most sense if you're analyzing these, but they're going to try to expand it. If you have the ability, whether you exercise it or not, I think it's very likely that you can have an issue here. Why does it matter? Well, obviously there are penalties and issues that come up if you're not properly classifying someone as an employee. Again, they're eligible for workers' comp. There's tax withholding issues. So the penalties can be significant if you have these. If you have any issues with this, I know of a lot of situations over COVID, and how this has come up is people who are retiring or leaving, and then the company says, we're just going to bring those people back as a 1099 independent contractor. Well, if they're coming to work only for you, they don't have their own tax ID number. They're coming to work and doing the exact same thing they were doing before. That is a problem. And I have seen that issue. So just be aware of that particular issue. Again, I've kind of already mentioned this. The NLRB is really focused on this issue. You know, I'm kind of biased on that because of the work I do in traditional labor matters. But it's very clear that the labor board wants more people than currently exist to be defined as employees. So they're going to be involved in pursuing that. And you can look for decisions and rule issuance from the National Labor Relations Board to make the use of independent contractors very limited and restricted. As I've said, there are all kind of ramifications at both the state and federal level. You know, in South Carolina, if you've misclassified, well, someone classified as independent contractor is not covered by our state wage payment law. So, you know, what you have to pay someone when their employment is terminated, the notices you have to give them regarding their wages and benefits, what you can deduct from their pay. Independent contractors don't have those same protections, and therefore employers of an independent contractor wouldn't have this exposure. But if that's been misclassified, you can have more significant penalties and damages. Another area that we see, because a lot of this has come up in the context of having a difficult time retaining people during the COVID pandemic, shortages of workforce. Employers have become very creative and innovative with trying to provide bonuses. So just be aware that non-discretionary bonuses, things that could be used to drive better work, more efficient work, those are almost always going to be things that are going to need to be included in the employee's regular rate of pay, and therefore will be an issue that needs to be addressed when you're calculating the overtime pay that somebody has. So you know, that comes up. So just be aware of that. If you're using bonuses or incentives in different areas, you know, just saying, well, these are discretionary because we didn't do them last year, we're doing them this year. That's not the analysis. It's really what is the current reason for why these are being paid during the current year, current pay period, and that's the relevant analysis there. You know, if you have a bonus or incentive that needs to be rolled into the process, you know, there are steps you need to take to calculate the new regular rate of pay and the new overtime rate of pay. I'm not going to go through this example. I went to law school, so I did not have to do math. But this is just sort of a basic example of someone making $10 an hour and works 50 hours and is paid $50 bonus. On top of that, you can see if that bonus is really to drive productivity, to push better work, more efficient work, and is not just a gift that goes out to everybody. It's going to need to be part of the regular rate and calculated into the overtime. And here you can see in that example at $10 an hour with 50 hours, so 10 hours of overtime, that there would be an additional $155 of overtime pay on that particular example. Going back to my reference to the Fisher & Phillips website, we have white papers available for calculating overtime on bonuses and incentives. So we have an extremely experienced and a capable wage and hour practice group. I am involved in that only to the extent that I identify these problems and problems that could come up and get you to the best experts who know exactly what to do in all scenarios. I know enough to let you have a better insight in what the problems can be, but we have some folks here that can do excellent work. So be aware of that. Another possible area of litigation is going to be remote work, and they're going to focus on paying people for all hours that they work. And there's all kind of issues. Now, at this point here in April of 2022, because there were so many people probably working remotely in 2020 and continuing to 21, this is probably something that you've already looked at, has been addressed. But there's two impacts from the COVID pandemic. One, the likelihood that people are going to want to continue working remotely, even when the impact of the pandemic is reduced, is real. People are out there wanting to do that. So if you're comparing 2022 to 2019, it's probably much more likely that you're going to have people working remotely. So it's just an increase in these opportunities. And then I do think there are attorneys all around the country looking for theories, facts, and circumstances to allow them to assert class action wage and hour matters. So I think this is going to be an area where they're going to try to mind it very vigorously. So making sure that you are paying for all hours work is going to be critical. And then the other thing is going to be the other costs that may be incurred by people working remotely. So that's another issue. So a lot of states are imposing laws that require you to reimburse remote employees for their Wi-Fi, their data plans, their cell phones. If we don't, and we don't have in South Carolina a state law that covers this, so the issue would be that at the federal level they impose some rules. So just be aware of that. So remote work, just be aware of how these folks are actually working, how you're paying them, what type of expenses they may have that could come up. Collective actions, again, we expect those to increase in 2022. Pay equity claims, different pay for the same work, and issues with that being a problem if you have employees of different sexes, failure to pay overtime, misclassification issues that I've already talked about. Then waiting time cases, dawning and duffing. There are an increased filing. As I said, there are lawyers that this is what they do now. They get out on the internet, they get out on social media, and they shoot these things out. And they ask folks, do you work in this industry? Do you work in this particular type of job? Are you properly reimbursed or compensated for all your hours worked and for all your expenses? So they're out there looking for these things. The white collar exemption and overtime, that is expected to come out, and that will increase the minimum salary. Could be proposed by the Department of Labor, could be as high as $82,000 by 2026. I don't know off the top of my head right now how many people that this would result in being covered by overtime white collar employees, but that's something that every organization should evaluate your vulnerability. If you have folks that are in an exempt category for overtime now, make sure that you are not having an issue or will have an issue if and when the salary minimum for the white collar exemption is increased. Then for federal contractors, there's an effort to expand the definition of federal contractors and subcontractors and all the laws that cover them. Davis-Bacon Service Contract Act, those issues are out there. So that's a very specialized and specific area of the law. So again, we have folks here that spend a great deal of time working with federal contractors and subcontractors. So, but be aware that that is an area where they are looking to more broadly define the folks that are going to be covered under those laws. And how much of an issue, how much of a threat are these things that I've just mentioned going to be? What is the risk level? Well, just, in President Biden's State of the Union address, he was pushing for a number of wage and hour initiatives, the pay equity and paycheck fairness legislation, paid family medical leave, and then the fight for 15. He brought those up specifically. So those are out there. Those are commitments and initiatives that they're going to be working on. So you can expect the agencies that are under the administration will be moving forward to really put a lot of emphasis and effort into those areas. Again, another plug for what we have at Fisher and Phillips. We have a lot of innovative technology services. And so we have a wage and hour inactive map that you can click on to get various laws that relate to wage and hour. So that's something that you can access through our website and get very good resource. We're spending a great deal of time, appropriately so, to gather data that exists just in the normal course of business, gather data from our clients from around the country. So we try to gather that data so that we can put that out there and kind of have our own version of people analytics so that people can obtain and have information. So all that's available on our website, and I'd encourage everybody to look at that if that's an area where you have questions or concerns. One of the things that has occurred is when President Biden came into office, he made the assertion he was going to be the most pro-union president ever in the history of the United States. So one of the things that he did in April of 2021 was put together this task force to address the problems that were causing the decline in union density. The vice president and other top federal agency leaders were part of this task force, and they had a period of time to come back with recommendations that would do two things: promote worker organizing, promote the number of people that can be organized, promote the number of people that belong to a union, and promote the effectiveness of collective bargaining. So that's what the task force did. The report came back in February of 2022. When the task force was put together, there were a lot of comments in the media. More conservative media would have described that task force as just an example of the president doing some outward open actions to give some tip of the hat to organized labor who contribute significantly to his political campaign. But there were questions about whether any real changes were going to occur. The report came out in February. There were 70 total recommendations. And I would have to say that I think the jury is still out on whether there are any hard and fast actions through this task force report that will actually have an impact on unions' ability to organize and the effectiveness of collective bargaining. The efforts by different presidential administrations to address traditional labor issues have always been there. And these always cover three main areas. They always want to focus on different and improved and increased ways that more employees can become eligible to be a union. And that's exactly what these efforts are, to make it hard to define somebody as an independent contractor. The more people that are defined as employees, the more people there are to be in a union. So adding more people who could be a member of a union. And then another area is going to be making sure that unions have a better chance of winning a union organizing effort by restricting an employer's ability to share facts and make sure people have an informed decision. Again, I'm a management side labor and employment lawyer. I've done this for a long time, but I have gone through a lot of campaigns and I've seen them run in different states by different unions. And I can tell you the companies that are subject to this enough that they have to regularly consider what their strategies and efforts are, they work extremely hard to lawfully respond to union activity. You will see in the media, all these references to union busting, and that's just kind of a stamp that is put out there by folks that are, I think, trying to justify restrictions on employers' ability to communicate. So, I do work with employers on how to lawfully respond to union organizing, how to lawfully answer questions, how to lawfully tell employees what their legal rights are, how to lawfully describe how the collective bargaining process works, how to lawfully discuss how strikes play a role in that process. But it is all on how to lawfully do those things, which are protected under our federal law. Anyway, so you'll see these efforts to restrict that. And then the final thing that you'll see administrations doing is trying to make sure that the collective bargaining process results in a final contract. See, under our law, that was written in 1936, if a union gets in, the company has to bargain with the union, which means you got to share information and meet at reasonable times and locations. But you don't have to reach a deal. You don't have to accept anything that the union says. Nobody can require you or force you to do something that you don't think is contrary to your business interest or the long-term security of your facility. That's the law. That makes sense. I don't know how it can ever be anything other than that. But that does result in a difficult issue for unions because they often can't live up to the promises they make to get them elected. So those are the three areas. So what happened with this task force? The main thing that's come up is that the federal government is going to make the federal government what they call a model employer. They're going to do everything that they can for people who work for the federal government to make sure that they become members of unions. And then they are going to provide recommendations that make it where employees of federal contractors are much, much more likely to become union members. So what are some of the things that are going to be happening? Yeah, I don't know who in attendance here may be a federal government contractor, but they are going to standardize the rules and processes so that union organizers have more access to military bases and other federal installations. They're going to give union organizers more access to contractor employees. They're going to peel back, reduce existing policies and procedures that have been implemented that restrict access. And then they're going to make sure that there are no federal rules and regulations in place that stop union organizers and pro-union employees from soliciting their coworkers and doing distributions on government property or in the work areas that are managed and operated by government contractors. So they're just going to make it easier for the union to get access to people. And the logical thought there is that if the union has easier access, more frequent access, they'll be able to recruit and organize more people. Then some of the other things that they're doing is once a federal contractor has a union, they're going to be pushing the federal contractor to communicate with the Federal Mediation and Conciliation Service, the NLRB, to try to help get through a contract. So you're going to, get the government's assistance in helping you work through that collective bargaining process, as I described a moment ago. That's the real problem. Once a union gets in, can they really do anything that provides a real benefit to the people who have voted them in and listened to their information? So yeah, they're going to make it where you have to at least communicate with the applicable federal agencies to try to push that process along. They're still not going as far as saying a contract has to be negotiated within a certain period of time. Those of you who have been around for a while may remember the Employee Free Choice Act, and I think even under the current version of the PRO Act, both those are federal legislative initiatives to help unions. There used to be proposals, there were proposals to say that if an employer and a union can't get a contract within, say, 60 days, then it goes to some type of conciliation process. And then if they don't get a contract with 180 days, then you go to some kind of interest arbitration. So they're basically was trying to guarantee a contract before a year, because once employees vote a union in, the union is protected for 1 year from the date the vote is certified, and are protected from being voted out. They can't be decertified within that year. That's what really makes the negotiations difficult. Unions have a hard time, getting the employers to agree to the things that they said to get support. They can't get that within a year, so they end up agreeing to significantly less in a contract than what they promised the members. And that's what starts the whole process off, or results in a very contentious situation. But anyway, for the federal contractors, they're trying to come up with solutions to that. Other federal issues, there's been a change to the arbitration laws. I don't know how many people participating in this webinar have arbitration agreements, but in February, Congress passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which means that employers who have arbitration agreements that limit and require restrictions on how disputes related to sexual harassment and sexual assault have to be addressed, can't have any issues with those provisions. So does this new law apply to existing agreements? It does, but it will only apply to claims that would arise before the enactment. So it's not a retroactive application, but it does apply to current arbitration agreements. But if someone says that the agreement that I had was enforced in an illegal, improper way according to this law, you have to look at, did that enforcement, did those actions occur after the enactment? Does it mean that all arbitration agreements, everything about them are void? No, but parts of all existing agreements may be void. Anything that applies to a sexual harassment claim after the law was enacted, you can't enforce, but otherwise it'd be an invalid agreement. But just be aware that It does come up more frequently. We have attorneys in our office here in Columbia that a good portion of what they do is handle the arbitration of employment disputes. I handle employment litigation and civil trials more so than the arbitrations, but they're out there. So if you have one, you might want to take a look at that. Then the last area that I want to cover is just some labor law and NLRB issues. This stuff is happening as we speak, and it's happening very quickly. I will tell you, I've handled union organizing campaigns in 30 different states, from Alaska to Florida to California to New York to Maine, all over. Right now in South Carolina, there's very little going on. There's some steel worker activity going on at a tire manufacturer in the Chester area, but that's been going on for a long time, over 3 years. The steel workers who represent a lot of the tire manufacturers in the US are declining. They're losing a lot of members, a lot of sway in that area. So they are working hard. They've been trying to organize and get a contract for a tire manufacturer in Macon, Georgia called Kumho. And they went through a long, drawn out process. The union is in at Kumho in Macon, Georgia, but they don't have a contract. So, but the big tire manufacturers have announced the closing of facilities, union facilities outside of South Carolina. We make more tires in South Carolina than any other state in the country. But anyway, so we have a little bit of activity there, but that's very specific. The tire industry shouldn't be a indication or concern for employers anywhere else. And I think the steel workers are having a very difficult time on that, but it is out there. So I'm gonna let everybody know that. We do have a couple, at least 2 of the Starbucks facilities, one here in Columbia, South Carolina, and one up in Greenville that have filed for petitions for an election with the union, the Starbucks union, which is basically a branch of the SEIU, Service Employees International Union. So I hadn't looked at that. You know, those are happening so quickly. The media would make you think that there's this huge wave of union activity. If you took out all these Starbucks campaigns and petitions, there would be less union activity this year than there has been, and it has been declining in recent years. Of course, you had the big Amazon election up in Staten Island. We'll see how all that plays out. The union, I think, again, lost in Alabama. But so there's a lot of media coverage. There's a lot of information out there. And I'm going to use the word mainstream. We'll just say the bulk of the media is going to report on union organizing in a way that's very favorable to the unions. So that's out there. What does that mean? It means your employees may be exposed to it. It may come up. So it's always a good idea to make sure excuse me, your supervisors know how to answer questions. Somebody reports union activity. But some of the things that are happening right now, the current top lawyer for the labor board, Jennifer Abruzio, she's the general counsel, has started this significant initiative to drastically modify labor board rules and decisions to make it so easy for unions to get in and so difficult for employers to maintain a non-union status. And yeah, I don't want to give too much of a history lesson, but some of the stuff I'm going to talk about, it precedes me and my old self in labor law. But one of the doctrines that existed years ago is called the Joy-Silk Doctrine. And you may hear that. I don't want to bore you with too much labor stuff, but in 1949, the labor board recognized this Joy-Silk Doctrine. And what the Joy-Silk Doctrine said was that if a union comes forward to an employer and says, I have proof and evidence that a majority of the employees want us to be their representative, an employer could only say no to that demand, could only say no to recognizing the union and starting to bargain if it had a good faith doubt that the evidence was valid. If you did not have a good faith doubt, then it was an unfair labor practice, an 8A5, as we would call it, which is a refusal to bargain. And if you could not show, prove, establish that you had a good faith doubt, you would be found guilty of that unfair labor practice, and the remedy would be ordered to bargain with the union. So that came out in 1949. That law was on the books until 1969, and it got crazier and crazier. The union's use of that strategy became much more aggressive. And finally, in 1969, it had gotten so crazy. I've been reading all these cases because this stuff's coming back up. And it is so hard to try to develop legitimate rules and guidelines to advise employers in 2022. We're doing it. You can do it. It can be done. But basically the labor board abandoned it. The Supreme Court recognized that process should be abandoned. The Supreme Court and the labor board recognized that the best way to determine if employees want a union is through a secret ballot vote. So that went away. Well, now Abruzio, starting in August and continuing now, is pushing for this return of the Joy Silk doctrine. And here is an example. I don't know if you guys can read this, but this is an example. This is what you're going to see today. This is in January. So I can tell you, Abruzio has been talking about this with all the pro-union folks and individuals and entities that would probably have her ear. And to be fair, when Peter Orr, the Republican general counsel, Trump's appointee, was there, management and companies had his ear. So it goes back and forth. So now the top cop, the top general counsel, is pro-union. So that's just the way it's going to be. And it's always been that way, but it's never been this aggressively one way or the other. And but this is an example of the letter. And what they're saying here is the union represents a majority of the people in a particular group at a particular employer location. And we want you to recognize us. And in here, this is one of the differences, is that we agree to an independent, impartial evaluation of these cards. In this case, it was cards, but it could be other ways. But this is there are, and just in the media this week, there were reports of a brief filed. I think it was a Cemex cement manufacturer that had multiple locations that went through a campaign. So it is already going up to the labor board to change this rule to where the demand cannot just be brushed aside. And this is a big point. Ever since I've been a labor lawyer, those of you that went through labor law training probably know that one of the setups that you're trained on, your managers, supervisors are trained on, is if somebody presents union cards to you, you just refuse to accept them, you don't look at them. And that guidance, those instructions, I never knew where that came from because I've only been doing it since 1988, not 1969. I always wondered where that came from. Don't look at it, don't expect them. You know, the training would be if the union organizer leaves it on your desk or whatever it is, put them in a box, wrap them up. Just don't look at the cards to do anything that say you authenticated the cards. And the reason why was the 1969 rule became that an employer just had the inherent ability to, if it wanted to accept the cards, it could. But if it just had a doubt as to the legitimacy of the cards, it feels that the secret ballot vote's a better process, it could just say no, and there's no unfair labor practice. So that's the law we're under now, but they're filing charges. So this letter I'm showing you here is from a charge that we've been responding to. But anyway, so it's out there. It's going to change. If you're an employer that thinks you're subject to potential union activity, you better know how you are going to deal with a Joy Silk demand for recognition. It is very nuanced. It's very fact specific. And yeah, almost every day I'm reading more cases, gathering more information. So I have a better resource of factual options to use in making legal assertions. So that's one. So just think about what I just said. So what I'm saying is the labor board is going to make it where having a secret ballot vote is very difficult, is much less likely, and that signing cards is going to be how employees decide whether they want to be in a union. So that's what's kind of occurring. So here's the next shoe. Just this past week, I guess last Thursday, the same top cop for the labor board, Jennifer Abruzio, put out a memorandum urging the labor board to correct the errors in our existing labor laws, to give employees what she says the right to refrain from captive audience and other mandatory meetings. So not only does she want to basically say that the best way or a regular way for employees to select a union would be to sign union cards, she wants to make it almost impossible for employers to lawfully meet with their employees if they learn about union activity and tell them what the employer's position is, which is a lawful thing to do, lawfully explain why the employer has this position, lawfully explain what the employee's rights are, lawfully describe and provide examples of how collective bargaining works, lawfully describe how the strike process fits into the collective bargaining. They're basically wanting to say, so we're just going to make it where you can put pressure on people, put pressure on people to sign cards. And if an employer finds out about that, it's almost going to be impossible to conduct meetings and even one-on-one. She's even saying that a manager going out during work time, having a work time interaction with employees would be a violation of the National Labor Relations Act. So it's going to impose all kind of crazy requirements for employers to show that every interaction is, quote, voluntary. I've always done this to a degree. You'll hear that term captive audience meeting. I've had the benefit of running campaigns with card check processes contractually imposed and neutrality restrictions contractually imposed by private agreements. And we're always able to succeed because we focused on how to lawfully communicate. And we never made meetings mandatory. We always said it's a voluntary process, just because the companies I work with did not want to be viewed as heavy-handed. And we always, because of their pattern and practice of communications, had very good attendance, which is the key takeaway here. You need to have very vigorous and consistent communications now. If you don't have those now when you're not talking about union activity, to try to start those up suddenly in response to union activity is going to be practically difficult and legally difficult. But anyway, so that's what's happening. Does the law prevent you from having meetings now, mandatory meetings? No. Does the law prevent you from telling a union to go pound sand if they present cards? No. But I can tell you the labor board is prosecuting those. They're filing charge. They're telling unions how to file the charge, what the evidence should be, and they're going forward. And when I talk to clients involved in union activity, excuse me, my goal is to make sure the companies I'm working with are not a test case. Yeah, I know what the law is now, understand that, but I don't want my clients to be a test case and have, because you know where Joy Silk, interesting point of history, Joy Silk was a textile mill in Hartsville, South Carolina. So that 1949 decision was based on actions and conduct related to a union organizing drive in Hartsville, South Carolina. So my goal was to make sure nobody I advise or counsel has a doctrine named after them that the labor board banties around for years and years. Well, that covers everything that I had. I don't know if we have any questions. Simone, I don't know if you have access to that. But if there's any questions, I'll be happy to answer some.
Yeah, I'll give you a few minutes to see if anybody had any questions, and feel free if you want to raise your hand and we can unmute you to ask questions. Mike, just for clarification now, is the Joy Silk, is it in place now, or is that something that the Labor Relations Board is going to be looking at?
The law, it is not the rule of law right now.
Okay.
But this is how this labor board as an administrative process works. Unions are filing charges. If that legal theory has already been asserted by unions and is being briefed by the assistant general counsels, for the labor board is pushing for that to be the law. So my point is, you're not going to be able to defend it because the labor board can't change a rule or a law or a decision until it has that in front of it.
Mhm.
And so what it's those issues are quickly getting in front of it. And unfortunately, the way the labor law is analyzed and applied, that doctrine can be applied retroactively. So it's not going to be, if the labor board issues a decision saying, we've now come out with Joy Silk 2022, it's not going to be like the law applicable to arbitration agreements. Events occurring after this date are going to be covered, things before or not. They can apply it to your refusal to recognize the union that happened 6 months ago or now.
Okay. Okay.
I don't know if that benefit helps, but it's a problem now. So it's not the law now, but it is a problem now.
I understand. Okay, I didn't see any questions come through, but Mike.
Simone, I have one.
Oh, okay, I'm sorry. Go ahead, Pete.
Mike, on the vaccine mandates, a while back, there were federal mandates put out about working on federal installations for contractors and the vaccine mandates. Is all that gone now? I know it was held up by lawsuits, but I never heard that it was done away with or anything.
Yeah, I think the actual the actual mandates and the administration, all that's been backed off it's been backed off now. So that is not the requirement. It's not part of, I think most of we represent a number of federal contractors. I think they've all received notice that that any contract provision that was amended and inserted does not apply, that they're not enforcing that. The case I have is with a federal contractor, excuse me, but we're litigating their private mandate. They did it prior to and in addition to the federal mandate.
Okay, my understanding was that they were injecting some FAR clauses for that. That never got done. That never became part of the FAR clauses that we have to deal with from now on.
I think that is correct. I think that's correct. Yeah, because everything's backing off as far as I can tell on that.
Okay,
Definitely.
thanks.
Yeah.
Okay. Were there any other questions? Okay, if no other questions, Mike, we appreciate you, taking the time to be with us this morning.
Yeah, always. Yeah, always.
Once again, we will have this recording up on our event page on our chamber website for future listening, and we'll also share Mike's PowerPoint there as well. I would like to thank all of you for joining us and have a great day.
Thank you, Simone. Thank you, everybody. Have a good day.